After a year or two, or even more abroad, you find that not only have you gained some incredible experience, but you've also fallen in love and gained a partner or spouse from your new home. The two of you have decided to return to Canada, and now comes the fun part. Assuming that your new partner is a foreign national to Canada, you will now need to deal with a complex and potentially confusing Canadian immigration process. In this series, we ask one of Canada's most respected immigration lawyers some of the questions that are often on people's minds. It gives me great pleasure to welcome Marina Sedai. Marina's firm, Sedai Law, is based out of Surrey, BC. She has been practicing immigration law exclusively since 2005 and is a past national chair of the Canadian Bar Association's immigration section. She joins me in this series answering questions about the process of bringing a foreign national partner or spouse back to Canada. Marina, welcome to the Canadian Expat.
Well, thank you for having me. I've been looking forward to this.
Marina, a couple has just decided to return to Canada. And because one of them is not a Canadian citizen or a permanent resident, they know that they will have to deal with immigration. So let's get right to the beginning of it. Even before starting the whole process, the whole application, what are the sort of things that one should consider before applying?
Right. So when a couple comes to me, the first thing that I'm going to do is not talk precisely about immigration. We want to take a look at the whole of their lives, their family's life, so that we can see all the variables that might affect the immigration process. So, for example, are they outside Canada, or when would they like to come to Canada? When they come to Canada, will there be children who have to go into school? Will the foreign national spouse need to be able to work? Will the foreign national need medical coverage? And if there's a pre-existing condition, such as pregnancy, that might be a challenge. That might have to affect the timing of arrival. So also what can affect timing of arrival is tax considerations. Now, I'm not a tax lawyer, but I always alert clients to this. They need to know, is there a certain time in the year that would decrease their tax liabilities across the countries in which they file? Or when they arrive, should they be renting instead of buying right away so that they're not immediately subject to the foreign buyer tax for the foreign national spouse? So there's a lot of other considerations that go into, okay, how do we approach the immigration process so that it serves all of your needs?
There's a lot to consider. So what are the potential problems that can come up?
Right. So the problems are, they should, of course, always be canvassed up front, but sometimes during the construction of the application and during processing by the government, stuff happens. So it might be that the couple is very surprised that they cannot get a hold of some documents that they need. So there could be delays or the need to, get assistance from outside of Canada to obtain those documents. It might be that there is a past issue, some historical issues for either the sponsor or the foreign national that can interfere with their eligibility to sponsor and to enter Canada, respectively. Other problems, a very common one in family class is where there is a child under the age of 22. So sometimes this is an adult child, but especially when it's a minor who's in the custody or living with another relative or a former partner, spouse, that child's parent, that can wreak havoc on the application process if that child cannot be examined medically, examined for their history if they're over the age of 18. So getting a hold of information and having things done to construct the application is one thing. Then during processing, there's all sorts of things that can delay. Maybe something will come up, an unexpected inadmissibility that no one anticipated. Maybe it's something that can be dealt with, but it'll slow down the process. There could be other considerations, such as sometimes the government makes mistakes. They might return an application that is, there's nothing wrong with it. The reason they're returning it, they just made a mistake. It's not a problem at all. Or maybe there was a deficiency and they return that application 2 months, 4 months, 6 months. I've even heard in an exceptional case of 12 months after it was submitted, which can just really throw the family's plans into turmoil. So one needs to know during processing, if they're being asked for something from the government, is that a legitimate request? Is it time to comply and get it as quickly as possible? Or is it time to go back to the officer and explain why that request shouldn't be made and that there's an alternative that will be easier on all parties?
A lot to consider. Marina, thank you so much. I look forward to next week.
Excellent. Thank you very much. I look forward to it as well.
And thank you for watching. If your questions are a bit more specific or perhaps complex, Sedai Law would love to hear from you. They're there to help. Make sure that you mention that you watched this episode. Their contact info is in the description. This is a series about immigration and is published every Thursday. Make sure that you like this video and subscribe so that you don't miss out on any episodes. Until next time.